the final case of the day, and against Ocwen and Loan.
May it please the Court, my name is Tom Pycraft. I have with me Mike Malkowski, who represents the appellant Annie Thomas. I would like to reserve 5 minutes for the hearing. Your Honors, this is an appeal from a summary judgment entered against my clients in a foreclosure action. The issues that we are raising on this appeal have to do with a number of affirmative defenses that were filed in the answer and affirmative defenses of the trial court, which were not addressed at the summary by the appellee prior to the entry of summary judgment. We also believe that the wrong standard was applied at the summary judgment hearing. There's also no evidence that the material document in this case, was in the possession and owned by Ocwen when they filed the case. I'll start with the affirmative defenses. Affirmative defenses were raised, they were numerous. The one that was raised in our appellate brief specifically is the 30-day notice of the intent to accelerate that we feel was not overcome prior to the entry of summary judgment. There is a case directly on point in the 2nd District Court of Appeals. It's Bryson versus BB&T. It's only a few months old, but it actually addresses the exact same fact pattern that we have here, where at the trial court level, they did do a notice of filing the letter that they purport to have sent to my client. The 2nd District Court said that's not sufficient. That's not good evidence. It's not authenticated. We can't rely on, at summary judgment, a document that has been filed by the creditor's attorney with that. It needs to either be accompanied by an affidavit or some other evidentiary foundation to get that document in. That's the same thing that happened in this case. I would rely on the same case for the issue with the summary judgment standard. If you review the transcript of the summary judgment hearing, there was never a showing by the creditor, by Ocwen, that no genuine issue of material fact existed.
Well, their argument is that, and I'm assuming that you're going to, as you did brief, assert that Ocwen was required to address all of the affirmative defenses?
Yes.
Right? So is your position that by failing to do that Ocwen did not even reach the point to which the burden shifted to your client?
That's correct. That's the issue. The BB&T case, again, addresses the issue of the standard on summary judgment, is that essentially the moving party has a very high standard where they have to essentially prove a negative.
Well, didn't Ocwen file some sort of a response to the affirmative defenses early on?
They filed a reply, but the reply doesn't amount to evidence at the summary judgment level that would have overcome their burden before summary judgment was entered. The response is still a simple pleading by the counsel for Ocwen. I don't believe that you can rely on the pleading to say that my client affirmatively, that they sent out this notice 30 days prior to filing the foreclosure action, and I don't believe that was competent evidence for the trial court to rely on. With the summary judgment standard,
Are you saying? What is your position? as regards the main case. In other words, if you had not raised any affirmative defenses, would you have to concede that summary judgment was appropriate?
No, Your Honor. And the reason for that is that would take us to the 4th District Court of Appeals case, the McLean case, that is another fairly recent case, where they found that in this case, just to give you the back up here for a second, the case initially contained a lost note count, and no photocopy of the note is then required to be attached. If there's a lost note count, you have to have some sort of statement of the terms of the note, and that's what they did here. So there's no evidence on the record that they were in possession of or had the note prior to filing. And so that was one of the issues that we could raise, was while it is, the court did rely on their notice to file an original note, that the note that they had at the time of summary judgment. Again, it wasn't authenticated. The trial court did rely on it. There was no finding by the trial court on the issue of whether or not they actually had it prior to filing suit. And they had to have it prior to filing suit, or they couldn't institute the action. Just because they may have had standing at the time of the actual summary judgment hearing happened doesn't cure the issue of if they didn't have it.
What case says that?
That is the McLean case out of the 4th District Court of Appeals, Your Honor. I'll get you the McLean v. J.P. Morgan case, February 8th of this year. And then...
All right, so in addition to the type of problem you're saying, you have the same authentication problem with the late discovered note?
Well, the authentication issue is separate, but the timeliness issue is what is addressed in McLean. It's a similar set of facts where the difference in that case is there actually was a copy of the note attached to the original complaint, but the endorsement on the note that they relied on at summary judgment was not on that note. In this case, we had no note attached, so there's no way they could be relying on the photocopy of the note at the time that they filed to show as some sort of evidence that they were in possession when they filed the complaint.
Well, when they filed the complaint also included an account at that point to reestablish the note, right?
Correct.
So your argument is that once they located the note, they then had to show that they had possession of it at the time they filed it.
Correct.
Doesn't that seem kind of circular?
Why couldn't they just amend?
Well, they could. There's an argument they could have amended, and I raised that at the summary judgment hearing that they should have amended, because there was a conflict between the lost note count that was still outstanding, and they walked in and said we had the original note, and I felt that at a bare minimum that was a genuine issue of material fact as to whether or not they had the note.
What I was trying to ask before was, as to the note, was there an affidavit saying how they got it or that they had it?
I don't believe so, Your Honor. And the way the note was filed, it was just, again, a notice of filing by the bank's attorney that said, here it is. There's still, it was filed on the record, but there was no accompanying affidavit or any other documentation. I don't believe the note, it's not notarized, it's not under seal. I don't believe it's self-authenticating either. The mortgage would be. The mortgage is a recorded document. But I don't know that the note itself is. I'm sorry, did I answer your question?
But you would concede that it was if it had been recorded?
I believe that you're saying on self-authentication. The self-authentication is actually, if we go back to the Bryson versus BB&T case, the 2nd District attempts to define self-authentication, and that's the standard that they use. If it's a notarized document, a recorded document, some sort of a document that has some sort of intrinsic evidence that leads the court to believe that it's stronger evidence than what would be normal hearsay evidence.
I know how does this work, but the Ocwen is a loan servicing.
Yes.
So they hold, but they hold in their own right?
Well, that's a great question. The law on that in this state has changed dramatically in the last couple of years. I'm not sure what Ocwen's role. I don't think it's clear what Ocwen's role really was at the trial court level. I know now. I know that there's a servicer now. But their actual role is a servicing entity. They typically don't own instruments. So I do think that that's an issue, but there have been cases that have come out, I don't believe in this district, but around the state, that have indicated that the servicer in some capacity can file a suit in its own name. I see my time is running short.
Good morning, Your Honors. May it please the Court, I'm Albert Zakarian from Consuegra Law in Tampa, Florida. We represent Ocwen at the trial court level and also here on appeal. This case really involves two issues. I know counsel didn't address one of them, which is the procedural issue that was addressed in the briefs, whether this court even has jurisdiction to hear the appeal. And the second issue, which is the major part of the appeal on behalf of the defendant, or in this case the appellant, which is whether the trial court was within its rights to grant the summary judgment. Now, this particular case is an appeal where defendant is appealing the fact that defendant came to the trial court at summary judgment and didn't do anything. And what that defendant is asking you here to conclude is that all you need to do as a defendant to defeat summary judgment is to file an answer, shotgun 23 affirmative defenses attached to that answer, and that's all you need to do.
No, I think that what part of the argument is that Ocwen did not sustain its burden at summary judgment because it did not present evidence refuting
Each and every of the 23 affirmative defenses?
Each and every one.
I understand that, Your Honor. I think that that is not the actual standard. The standard of summary judgment, for sure, is a difficult standard to overcome in most cases, and it's usually reserved either for uncontested matters, especially when you're dealing with foreclosure cases, or it can be used where the case on the other end of a heavily litigated case where you have a lot of depositions. That's not the case here. In this particular case, and
what was Ocwen's responsibility relative to the affirmative defenses?
Their responsibility was to come forth with evidence to show their main claim and to deal with affirmative defenses that controverted it. In this case, you have 23 different affirmative defenses. Some of them are purely legal arguments that have nothing to do with the actual evidence presented to the court. Some of them actually address factual positions, but they're mere assertions. You can't just have 23 one-liners and expect to defeat summary judgment. You have to come forward. Remember, in this case, this defendant, Annie Thomas, was represented by counsel since December 20th, I believe, or 29th of 2009, not long after this case was filed. The attorney that represented Ms. Thomas then was hired by Mr. Pycraft's firm. So she essentially has had representation for years prior to the summary judgment motion. She files nothing in the court record to support any of her affirmative defenses or even suggest that they're legitimate whatsoever. She then comes to the hearing, and actually, let me correct myself, she doesn't even show up at a final summary judgment hearing.
I don't think that's necessarily relevant. I guess my question is, even assuming that the affirmative defenses make mere factual assertions,
right,
is it not Ocwen's responsibility, or was it not Ocwen's responsibility at summary judgment to show, to demonstrate that there were no issues?
Disputed issues? Well, I believe that the evidence that was presented was sufficient to defeat each one of those defenses. I don't think Ocwen has to come into the trial court level and say, Your Honor, we're here for summary judgment. Let me run down each one of the 23 affirmative defenses. What Ocwen did do is they came to the court.
Why do you think that?
Because I think Ocwen's required to come to the court with their affidavits, which they did, with their filed documents, which they did, with their reported documents, which included an assignment giving them standing the day they filed the complaint, which included the self-authenticating note with blank endorsement on it, which included the certified copy of the mortgage. All of those pieces of evidence dispose of a lot of the affirmative defenses without having to march through each one of them at the hearing. And I'll also note that this particular hearing in front of trial Judge Bowden, the defendant came with his hands open, didn't give Judge Bowden almost any other option but to grant summary judgment.
Aaron Bowden.
Oh, Bowden. I'm sorry, Your Honor. I'm from Tampa. We're not that smart down there.
I knew you were from out there.
Exactly. But really, defendant doesn't give Judge Bowden any option but to grant summary judgment, because when Ocwen walks in with that, plus their affidavit in support, which includes a business records language in the affidavit, it attaches the payment history, it attaches the judgment history, it attaches the documents including the note and mortgage, so that Ocwen is putting on the full case. And I am prepared to. But if you look at each one of these affirmative defenses, these affirmative defenses, remember, were filed in December of 2010.
All right, what about the notice of intent to accelerate?
The notice of intent to accelerate was filed. In this particular case, it was part of the record as a document. It wasn't at that point that it was filed. I agree with counsel. It wasn't a piece of evidence at that point. Once Christina Carter from Ocwen puts her affidavit in, says the necessary business records language, and that is then presented to the court can then conclude at that point that defendant has received notice. If you look...
What are you talking about, testimony?
No, the court can conclude at that point that because Ocwen's relying on the notice of intent to accelerate as well as other documentation, at that point it is a business record. Ocwen put in their affidavit supporting that Ocwen owned and held the note for the purpose of the foreclosure, that Ocwen was the servicer. If you look, and it's very telling...
No, but what was the authentication?
On the particular document, it was a business record. There wasn't separate authentication from that. But
So you agree it's unauthenticated?
At that point, finally, it definitely was.
And at that point, I believe you just told us it would have been improper to rely on it for summary judgment.
At the point of filing, but once you get to the summary...
What changed?
Well, when you get to the summary judgment, you have the affidavit in support of the summary judgment, which tells you that Ocwen's the owner and holder, that their business records are part of this loan, and that's what we're relying on at that point. You'll notice in this hearing, this is a 13-minute hearing. This is not a long hearing. Mr. Pycraft, on behalf of the defendant, presents nothing except when you go a couple days later, the motion for rehearing. Interestingly, this is the first time we see an affidavit from the defendant. And the affidavit says in paragraph 8, I did receive a notice of transfer of servicing, which is one of the affirmative defenses. So she then blows out one of her own affirmative defenses in her affidavit. She never says that she didn't make the payment. She never says she didn't get the breach letter or receive the breach letter, which you would think in defending these cases would be the easiest way to avoid summary judgment.
Well, let me ask you this. At the hearing, I realize these are rocket doctor kind of things.
Right. This is an older case, so it probably was.
This is time of the essence, but at the same time, when you go in with your client, they have defenses. Did you at least address those defenses and say, Your Honor, defenses 1, 2, 3, 4, those are all legal issues, and here's why we can move our way. And these other ones, there was certainly any attempt at the hearing, it was only 13 minutes, for your client to overcome those defenses.
I don't know, Your Honor. There wasn't any particular testimony where my client's going to come in and say, hey, each one of these 23 defenses is insufficient. Because in this particular instance, a lot of them are legally insufficient, even at the time they were filed. I mean, they're arguing in some of these defenses lack of failing to attach notes, lost note counts. These are 6 to 9 months after the original note is put in the record with a blank endorsement.
But at what point was that argument made to the court that the defenses were legally insufficient? Did Ocwen file a motion to strike the defenses? Or?
No, we filed a reply to the defenses as opposing counsel.
So it's another pleading, basically.
Right, it's another pleading. But that's my whole point with this argument, though. Who was the
original mortgagee?
The original mortgagee was Taylor, Bean, and Whitaker. and they were located here in Florida. They were simply a loan origination company. In fact, I attended the deposition of the person that actually signed the blank endorsement in this case and did it in a lot of the Taylor Dean cases. And what they would do is they would originate the loan, and then they would blank endorse and immediately sell the loan. And that's what they did.
All right, so even when the paper turned up, it wasn't endorsed in your favor?
It was endorsed in blank, correct, which is even better because as many of the cases have said already, it's bearer paper at that point. And that was filed with the court about 3 months afterwards. Now, I understand the way that these cases were going, as Judge Maker said, with the rocket docket and so forth, cases were being filed with lost note counts, and then those lost notes...
You to another Jacksonville judge, this is Judge Makar.
Makar, I'm sorry. But in that particular case, and let me just address that for a moment, Your Honor, the lost note count by the time of the summary judgment hearing is moot. But as this court knows, in January of 2011, I think it was, Rule 1.420A was revised, so best case scenario, we could just voluntarily dismiss count 2 if that's an issue, but it's certainly not a bar to foreclosure when we have an original note with blank endorsement sitting there. I think that the key part of this appeal, and I think it's going to create a very dangerous precedent, is being asked for by the defendant is, can we just shotgun out as many affirmative defenses as possible with no support whatsoever, show up at a summary judgment?
That's a very serious charge.
It is, and I'm making that charge. I think that's very serious.
Well, this is not the forum, but I don't know of any reason not to assume that these defenses were interposed in good faith.
They may have been interposed in good faith. I'm not talking about the faith aspect. I'm talking about you go ahead and file those, and then you show up at the summary judgment hearing without having anything in opposition, without having any support, and many of these were already moot or legally insufficient when they were filed.
Was it not your burden at summary judgment?
Well, I think that's exactly what the defendant wants you to conclude. They want a case that says when you go to summary judgment, in addition to presenting your case, you also have to march through every affirmative defense, regardless of how many, regardless of whether they are legally sufficient, whether they are ridiculous at the time of filing. For instance, where's the note when it's been in the court file for 9 months?
I think there's actually a case law, though, that says that when a defendant raises affirmative defenses in his answer, the plaintiff, in moving, well, I guess it's the plaintiff, in moving for summary judgment, must conclusively refute all such affirmative defenses raised by the defendant before he will be entitled to summary judgment. That's the City of Hallandale,
right?
The State Extra Stage Work out of the 4th BCA. I don't understand.
So I don't
understand then why Ocwen wasn't required to refute all of the affirmative defenses.
I think it's procedural. I agree with Your Honor as far as citing the case law. But the question then becomes, at a hearing, do I actually have to say I'm refuting all 23 defenses? Or can the court take note of the 23 affirmative defenses and then decide on its own that based on the evidence that was submitted to the court, which in this case Judge Bowden did, he had the evidence in front of him, he concludes that those affirmative defenses were defeated. I mean, perhaps we don't know what the answer is on that.
So maybe that's your best argument. Your best argument is that the trial court is perfectly capable of determining...
making that determination on its own and deciding, as he did in this case. I mean, if you look at this particular case, the judge says on page 10, which is record page 306, it says, all right, I don't disagree with the language you quoted, and they were talking about the exact issue, Your Honor. I do agree, however, that had an appropriate affidavit been filed setting out the facts and controversy, material facts, I would have denied the motion for summary judgment. Here, there is nothing that controverts the allegations in plaintiff's pleading, so I'm going to assume that all of that evidence and supporting affidavits, he says, is true, which probably he meant are true. What he's saying is, I've got this record evidence that plaintiff has given me.
Is the foreclosure complaint itself verified?
This one isn't, and that's a good point. But we do support those allegations with the affidavit that was put into the record by Christina Carter from Ocwen Servicing. Plus, we're also relying on the original note, which I believe is bearer paper and was filed with the court 9 or 10 months earlier. And we were also relying on the assignment and the recorded mortgage, both of those recorded documents. And the assignment actually was done the same day as the complaint. So it resolves a lot of these different affirmative defenses. And Judge Bowden, as the senior judge sitting on that case, could have easily resolved those issues in his mind and said, you know what, I'm aware of the answers, I'm aware of the affirmative defenses, but guess what? I'm granting summary judgment. He's well within his rights to do that, especially in a non-jury trial. And I think that that's what he did in this case. Defense counsel could have easily brought that up in the hearing. Defense counsel had an opportunity in this 13-minute hearing to say, you know what, I want to march through all of these affirmative defenses, or maybe I want to pick and choose the important ones like they did on the appellate briefs. Why not, while you're in front of the judge, start making those arguments and force plaintiff to do something about it? I mean, honestly, I do these cases all the time. I'm not a particular fan of summary judgment because I understand the high standard. But if you look at the record in front of the trial court, defendants left the trial court virtually no choice. They gave you nothing, and they were involved in this case from almost the beginning. I think there's no reason to reverse the trial court, see any abuse of discretion or any kind of standard here, even if it's de novo. The evidence negates those defenses, and I can do that one by one, but I don't have enough time to do so. I think the court did it, and the court made his decision based on being aware of the pleadings in the record and being aware that the defendant didn't show up at the summary judgment with anything. I see my time is up. Thank you, Your Honor.
Thank you, Mr. Zakari. He says there's nothing here. It'd be a waste of time to send it back.
I understand that he says that, Your Honor. I believe, based on his explanation of the summary judgment standard, that the point that we are appealing is of great importance here because it seems to be misunderstood by opposing counsel as well, that if my client doesn't file an affidavit, I can't survive summary judgment. That's essentially what he's saying. I believe that's what the trial court judge said. I simply think that that is not the case. The burden is on the moving party, not the non-moving party in a summary judgment.
Well, let's assume he's right that some of these defenses are legal issues that the trial court just decided on the record presented to the trial judge. Which are best defenses here that fall outside of that law? In other words, which ones are based on factual issues that the trial judge should have had some additional evidence from?
Yeah, the biggest issue is the one we raised in the appellate brief, which is the notice of intent to accelerate. We took that, and since then, the BB&T case, directly on point, this exact same thing happened. They filed as a notice of filing, unaccompanied by an affidavit. Somehow, their argument is now that they can file an affidavit after the document, and yet that all of a sudden makes that document authenticated as evidence.
Well, it depends. Why can't it? It depends on what the affidavit said, right? It said that records custodian did authenticate the notice of acceleration by a later filed affidavit.
I don't believe that's what happened. I believe what the argument that he made was that they filed a general affidavit that says, attached are the business records. I understand the business records. I'm making this on personal knowledge. I don't want to say for sure, but I am 90% sure that document was not attached to the affidavit. It was filed separately, and they were relying on that separately, which is identical to the facts that the second DCA was presented with in the BB&T case. Also,
Is that it? Is that the only defense that relies on the factual issue?
that's the only one we raised in our appellate brief because we thought it was the strongest, Your Honor. Just trying to simplify the issues. As far as the assignment of mortgage, which he relies on, he points out that it was dated the same day as the complaint. That actually raises a genuine issue of material fact as to whether or not it was done prior to the filing of the complaint or after. Typically, we see them several days prior to the filing of the complaint, so there is no misunderstanding. But when it's dated exactly the same day that the complaint was filed, I don't think that that's conclusive, that showed that they had standing at the time. I think that that's, again, a lot of these arguments are great arguments if we had proceeded to trial. But we stopped at summary judgment, and I think that that's where the crux of this argument is that the standard is substantially higher at summary judgment than it is at trial for a reason. And we believe that the standard that Judge Bowden used was, and I understand, as Judge Makar pointed out, the issues that we're trying to condense so many foreclosure cases into a short period of time with limited judicial resources. But I think it's important that we don't push the burden over to the borrower in this. It's typically the borrower. It's usually the creditor moving for summary judgment. And if we put the burden to survive summary judgment prematurely on the borrower, we're likely to make mistakes going forward. And if we're going to take somebody's house, I think that the importance of getting that right is very, it's a very very difficult issue, but I think it's a very important one. Thank you, Your Honor.
Thank you, Mr. Parker. That concludes the docket for today.